Welcome to Channel 17, the Town of Colonie Government Channel.
All right, thanks for coming, everybody. This is Steve's 5th time here, so I think he's our all-time reviewer here. I already apologized to him for the choice of the book, and he'll tell you why in a second. But anyway, you guys all know him. You wouldn't have such a big crowd. Steve's Connell and Aronowitz. He's on the radio all the time. Occasionally, we see him on TV, too. So here's Steve Coffey to tell us about retired Justice John Paul Stevens' memoir called Five Chiefs.
The crowd gets younger every year.
I know.
Thanks, Joe. This is my 5th book. I forget what the other ones were. One was about Nixon. The last book, actually, I reviewed
was Scorpions.
Yes. Who said? Right. Which is a great book. I don't know who was here for that, but that book was about the 4 great Supreme Court judges of the post-war era. Actually, it came before World War II. Jackson, Frankfurter, Black, and Douglas. And he wrote really great stories about the 4 of them. And one of the things he wrote about them, which a lot of people don't know, and people who have read Scorpions, is how much they disliked one another. Black, for example, hated Jackson because, and don't worry, I won't digress too much, and the reason why he hated Jackson is because although Black had been Jackson at a conference had challenged his integrity, and as a proud Southerner, you just didn't do that, and Black never forgot. In fact, he may very well have taken out Jackson as the Chief Justice in 1946. And then there are a couple other books about the Supreme Court, a lot of books really. One of them is the 1976 book, right after I think All the President's Men, The Brethren by Woodward and Bernstein. And that was really about the Burger Court in 1976. Then Jeffrey Toobin wrote a book a year or two ago called The Nine. And The Nine is about the Supreme Court judges, and Joe was saying he had read this. I think that Sandra Day O'Connor may have been the source for a lot of the stuff in that book. And then you have John Paul Stevens, which in many ways this book is dreadful. And the reason why, I mean, Joe was telling me that actually it's gotten some good reviews from some people. It's good in the sense that he gives you an historical analysis of the Supreme Court. It's very short. My impression of the 5 chiefs, and I'll discuss who they are, is that John Paul Stevens is about 92 now. And my sense, as I indicated, was that he was sitting around, he had nothing better to do, and what the hell, as long as you're at it, you might as well write a book. And if you're going to write a book, write about books that you know something about. He doesn't criticize anybody. If you read his book, and I'm Catholic, there's this old story, when the Pope is elected, and they go knocking on the door, and Pope, Giovanni is, it's wonderful. And they knock on the door and say, you have been now elected the Pope. Oh, the Holy Ghost is wonderful. Who could have thought this? Ignoring the fact that he's been campaigning for this thing for the last 10 years. And so, it's just such a myth. Well, if you read John Paul Stevens, there's a bit of a myth because he doesn't criticize anybody, and the decisions are all very heartfelt and collegial. And they have honest disagreements, are all basically doing their best, which is belied by those other 3 books I told you, because you get in these books how much some of them absolutely can't stand one another, both from personal grounds, which are the Scorpions. A lot of them, philosophically, they actually were philosophically very similar, but personally they just couldn't, they didn't like each other. Now, John Paul Stevens is unique in a lot of ways. He is the last, well, he's the second last judge. David Souter being the last, but anytime you appoint a judge who's single and lives in the woods with his mother, you don't know exactly what you're getting. Bush appointed Souter based upon the recommendation of John Sununu, who was his chief of staff in New Hampshire. And they all thought Souter was going to be this great conservative from New Hampshire, and turned out to be a tremendous liberal. They hated Souter. The conservatives absolutely hate Souter. He's now retired. So there was a judge. Now, when you get appointed to these positions, they are vetted, using that word, so completely that it's unbelievable how much they know about somebody. Let me give you an example. Now, the liberals are the same way. If you think Obama is going to put anybody in that Supreme Court that he doesn't know precisely how he or she is going to think, and 90% of the times, we're crazy. There was a judge in Albany called Judge Minor. And Minor just died. He was the Second Circuit from Columbia County. And his wife was very, very involved in politics. He was Jewish, he was conservative, he was Republican. A conservative Jew who was Republican. He was perfect for the Republican Party. He was telling me that he was on the short list. Now, when you get into the Oval Office, they'll float a bunch of names. When you get down to 5 names, 3 names, really, that's the short list. That's where that comes from, of people who might get appointed. Then you're inside. He told the story about how in 1980, a man had taken an abortion case who did not have what they call standing. So he went to the New York State Court of Appeals and tried to ban abortions in New York State, but he wasn't a father or mother, so he had no standing, and the Court of Appeals tossed him out and said, you're not a citizen, you can't bring cases in our courts for no reason. So he went to federal court under a federal cause of action, and Minor tossed him out and sanctioned him as a frivolous lawsuit. He had no basis personally being there. He was taken out of the off the short list in the Oval Office because the right-wing conservatives said he's an anti-abortion, he's an abortionist, that he's pro-abortion. And he laughed, he said, I'm not pro-abortion at all. But that was the law, it was very simple. But the people in the Oval Office who were advising the president said, he's not one of us. When you see Scalia get appointed, Kagan get appointed, Ginsburg get appointed, again, they know exactly where they're going. Souter was one example, John Paul Stevens is another. John Paul Stevens was appointed to the Supreme Court in 1976. He was either the longest or the second longest serving member of the Supreme Court in history, appointed by Gerald Ford. Stevens became one of the, maybe that's not the word to use, great, became one of the outstanding liberals, or one of the real liberals on the Supreme Court. And inevitably, he would always vote with a liberal majority, minority as ever it was. I'll give you an example of that. 2000, the seminal case in this country that won the presidency for George Bush, 5 Republican appointees. At the time, there's Rehnquist, O'Connor, Kennedy, Scalia, and Thomas. All vote for Bush, no recount. At the time, there was Souter. Ginsburg, I think, was on the Supreme Court at the time. Souter, Ginsburg, I forget else, and Stevens. Stevens always, and he was appointed by a Republican. So his background is very liberal. He's also interesting another way, which is not reverse snobbery. He's the last justice, or the only justice on the Supreme Court when he left, who was not a member of the Ivy Leagues. All 9 judges, and if you want to talk about how now internalized it is and how you get this idea that you have to be a certain group, are Harvard and Yale, all 9. They may have gone to different colleges, but they all come from those 2 law schools. Stevens was different. He went to Northwestern, which reminds me of another story about, I don't know if any of you saw or read the book by David Halberstam, The Best and the Brightest. In The Best and the Brightest, Johnson comes into Sam Rayburn one time, and this is where this phrase comes from. And he says, Mr. Sam, he says, these men are the greats. He says, I'm sitting here, and they're from Harvard, and from Yale, and MIT, and president of Ford, And, you know, the degrees, he says, these are the best and the brightest. Or the best, I don't think it's best and brightest, but that's where that phrase, they're the best people in America. And Rayburn looks at him and says, that may be, Lyndon, but I'll tell you, I've got a problem. He said, what's that? He says, there ain't a damn sheriff among them. And that's Vietnam. Remember McNamara with all the charts and everything else, and Bundy and all these guys, and they were men, are all doing these flow charts and everything else, and Rayburn was right. There wasn't anybody who was different. Well, now you've got the Supreme Court, and you've got this idea the American Bar Association passes on everybody, up or down, whatever, and somebody last year almost was appointed, I think, or a couple of years ago when Kagan got appointed, went to the University of Montana Law School. And of course, all the people, the liberals in the East could not possibly imagine that someone from the University of Montana could possibly sit on that court. So you've got that bias now, which is on the court. They'll deny it, but nonetheless, they're all intertwined. Many people, presumably since you're here, you understand this, we think of Congress and we think of the president and all their power. The power of appointing of judges is phenomenal. One of the things John Paul II made sure of, before he died, he was, what, 20 years, 30, whatever he was. Even though he was losing his health, the one thing he could do near the end was he could appoint. He appointed all the cardinals. And appointing all the cardinals would mandate that Benedict would come in, and now Benedict's appointing all the cardinals. And they're all conservative, so guess who the next cardinal is going to be? The chief judge has appointment power of certain judges in certain cases, and he talks about that in this case. And the presidency is important because the Supreme Court is so critical as what they can do. This month, by one vote, we're going to probably have two major, well, not probably, we will have two major pieces of litigation decided probably by one vote. The immigration cases out of Arizona and the health care bill. And if the health care bill comes out 5-4 and the immigration bill comes out 5-4, it'll be along party lines. But that's the tremendous power that the Supreme Court has in this country. Now, he talks about the five chiefs, and the five chiefs are historical. There's a Chief Vincent who was the judge after the Second World War, who was a close friend of Harry Truman's. And Vincent's interesting in some ways because Vincent died in 1954 after the first argument in Brown versus Board of Education. In the Scorpions, they point out, had he lived, Brown versus Board of Education, probably, if not the most important case of the Supreme Court in the last 200 years, certainly one of the two or three of them, Vincent may not have gone that way, and it was 9-0 at the time, so it was unanimous. Vincent was also unique in another way. Back in the old days, in the 40s and 50s, Supreme Court judges regularly associated with the president. Douglas used to play cards with Roosevelt, and Frankfurt was a friend of Roosevelt, and Vincent was a very close friend of Truman's. And in the early 1950s, there was a steel case where there was a war, and the unions were going out, and Truman took over the steel mills. And supposedly Vincent had convinced him ahead of time, don't worry, if you do that, you're okay in the Supreme Court. Well, it turns out Vincent didn't go along with him. He actually voted to revoke it. Of course, Truman went wild at this. But those were the days when you had this kind of separation. So Vincent worked through, Stevens talks about his time with Vincent as a clerk, and then he talked about private practice, was appointed, I'd say, in 1976, had some contacts with Berger. Now, Warren Berger was a former governor of California, a hugely popular man, and run, I think, for, actually, he may have run for I think he ran for vice president with Nixon, or no, with Dewey. And supposedly, he said, the only good thing about that election is I didn't get elected, so I'd have to be with Dewey for the next 4 years. So Berger was a very common sense sort of fellow. And actually, one thing about this book that is pretty good, Stevens talks about the personalities of the various judges.
Warren ran with...
Or Warren. I'm sorry, Warren. I keep saying Berger. I apologize. Warren. I miss it. Because I think of Warren Berger and Earl Warren. I'm sorry. So Earl Warren was the governor of California, and Eisenhower called the worst appointment he ever made when he appointed Earl Warren to the Supreme Court, made him the chief. He also made William Brennan the judge on the Supreme Court, which didn't make Eisenhower awfully happy. He had two liberals. So Earl Warren, if you remember the Warren Court, from about 54 to about 1969, that was a year of tremendous upheaval in our country, voting rights, segregation, criminal Miranda decisions, all those decisions. Warren was never considered a great thinker, but is somebody who really guided the court. And you had those, a lot of those 5-4 decisions at that time, and you had a lot of the old judges in the 40s who were starting to now obviously retire or die. Black went out in the 70s, Frankfurter went out in the 70s, Douglas stayed out in the 60s rather, Douglas stayed into the 70s, Harlan, a great conservative, was leaving at that point in time, Jackson died in the 50s. But so in 1969, then Warren Burger became the chief judge of the United States Supreme Court. Burger's interesting in a lot of ways because Burger, when you read Stevens' book, you wouldn't get this sense at all. When you read the other books like The Brethren, Burger was held in very low esteem by many of the liberals on the bench at the time, Douglas being one. Stevens came in, he wasn't quoted, I don't think, at length in The Brethren because he had just come on. But this is after Warren. So Burger comes on, he lasts for about 10 or 15 years or so. And then and one of the points out that Stevens, and you can see where Stevens gets a little annoyed at this, the chief judge on the arguments, it's pretty interesting these things have been historic, they shake hands before every meeting. And the junior judge is the one who always answers the door. So you want to make sure someone dies pretty quickly, because then they knock on the door, and when they're in conference, they're not to be disturbed at all, even with cell phones now. So they are not, except in an emergency, they're not to be disturbed. The chief judge, when you see an opinion written, if he is in the majority, he will designate who is to write the majority opinion, which obviously is extremely important. If he's in the minority, dissenting, the senior judge, in this case Stevens, as he passed through his term, senior in terms of service, would be the one who would write the decision. So Burger, for example, assigned to himself the decision in 1974 on the Nixon tapes, which you might expect. Other decisions over the years, if they had someone who was particularly strong in an area, he would designate that. But apparently Burger did not do well in keeping track of votes. So later they would come down and have a vote. And, when you read some of these Supreme Court opinions, where do you see this health care bill decision coming down? You have 9 judges. You may actually have 15 opinions with 9 judges, because what will happen will be this. You may have, say, Roberts or Alito writing the opinion. Now, Roberts, assuming he's the majority and everybody thinks it's going to be declared unconstitutional, it's going to be 5-4, Roberts will assign the majority opinion either to himself or somebody else. Let's assume he assigns the opinion to, say, Scalia. Scalia writes the opinion. Now, when they write the opinion, they'll pass it around chambers and back and forth, and clerks, in a lot of ways, will have a tremendous influence. For example, Thurgood Marshall, who was a darling of the left, his last number of years in the court, he was just showing up. I mean, if it was something involving criminal rights or anything involving segregation, Marshall was, for whatever, it was against the government. It's just the way it was. And the clerks did all the work. They just handed an opinion to him and he would write it. Others are different. The case coming down in the next couple of weeks, you may have, say, Scalia, for example, write the opinion. You may then have Roberts, for example, as concur and dissent in part. So he may concur in parts 1 through 4, or Roman numeral 1 through 4, and dissent on 5. You may then have Kennedy concur in the result, meaning I agree with the result, I don't agree with the reasoning, and he may not agree with, say, 2 through 6. And these go all over the place because everybody wants to get his pitch out and his oar in the water and so forth. So when you see this opinion, you're going to see an opinion which could be 70, 80 pages long. But the lawyer is going to do one thing who argued it, which we always do. You read the last page first. I didn't want to know if we won. I didn't know a good lawyer won the Court of Appeals 4-3. I said, close vote. He said, yeah, but I got the 4. So you'll see that. Now, Berger was not recognized as a great scholar. He was a chief, so you have a certain amount of respect, of course. He then went out, and who succeeds him at that time? One of the great writers of the Supreme Court and one of the really rocked-rib conservatives, and a man who then really gets enormous power. He's only the chief, but he has power, and that's Rehnquist. You get the feeling that Stevens does not like Rehnquist. He appreciates his intelligence. Rehnquist oddly enough, not oddly enough maybe, was very widely liked by clerks and other people. I know a woman in my office who once went to a seminar, a week-long legal gathering in Montreal. She liked him. He wouldn't talk about cases on the bench, but that he had decided, principles he would. But she said you'd see him in Montreal walking around. He was friendly, how are you, remembered names, and so forth. Douglas, the great liberal, people despised. He was a curmudgeon, treated his clerks terribly, constantly threatened to fire them or did fire them. So he was somebody, and of course he had 19 wives or something, so Douglas, his mind was on a lot of other things in the law. Now, Rehnquist gets appointed by Reagan, and he now becomes a real strong voice and a good writer. And there's no question that the Rehnquist court, because now, don't forget, you have 12 years in office. Reagan has 8, Bush has 4. And a lot of your Supreme Court judges who now populate the Supreme Court stay there. So, for example, Rehnquist was on the court until, I think, 2006, 2007. But he died. Scalia was appointed during this period of time. Thomas was appointed during this period of time. Thomas never asked questions. He's gone 4 years, and he sits there, and no one knows what he's doing because he asked no questions. In fact, I knew somebody who was interesting. He said, he actually, the Supreme Court, he said, Thomas actually asked a question, and the whole court, everybody turns around. They couldn't believe it. So wherever Scalia is, that's where you're going to find Thomas. But that was the same with Brennan and Marshall. So, that's the way it works. And they're there, by the way, if you didn't know it, for life. And when they mean for life, they mean for life. Stevens just came off at 90. Rehnquist was dying. And in fact, the book, The Nine, they talk about this. And they went to him, and they said, we think it's a good idea that maybe you think about resigning. He said, do you really? Well, I don't think it's a good idea. And I'm not resigning, and I'm staying as a chief. So Rehnquist gets appointed. According to Stevens, runs a very good ship. You get an hour for argument. He says he's very cordial, but he doesn't like his ego. He talks about how Rehnquist had the trappings of office and didn't care much for his ego. With regard to Rehnquist, while he's bright and intelligent, and they descended a lot from each other. The problem with the book is it gives you a history. If you don't know anything about the Supreme Court, actually it's pretty good because it gives you the history, gives you an idea about the tradition and how things, why they work. One thing I think I'd heard, I'd forgotten it. Usually when you argue in front of a court, maybe that last table there, I'm standing up here and I'm the lectern and the judges will sit back there. And people who argue there will tell you how scary it is. And you're told ahead of time, but when you walk in, it's really scary. You're 6 feet from the bench. So if I'm standing here, maybe this row right here, and they're right here, sitting right over you. So you're not back. I mean, you're right there. And it's what's known as a hot bench. Oftentimes lawyers will be very critical or very unhappy because they don't get questions out. In fact, if you saw this thing on TV, or now I guess they didn't have it on TV, but you heard about it, on the healthcare arguments went 2 days, they were simply asked questions the whole time. I mean, you get your name out and a little more, and that's about it. Rehnquist led the court in a direction to the right, and of course he had the appointments. And one of the things that come up, be careful what you ask for, in 1988, Bork, who was the Solicitor General, was nominated by Reagan. Kennedy and his crowd really went after Bork. And Bork had written a lot of opinions, and he'd written a lot of law school articles, and he made a huge mistake in his confirmation hearing. He told the truth, number one, because they all lie. They all lie. I mean, they really do. You asked, do you have any opinions on abortion? No, you know, it hasn't come before me. I don't know what I would think about that. And capital punishment, what's your view on capital punishment? That's a very good point. Knowing full well that this judge is never, ever going to vote to reverse the abortion opinion, Roe versus Wade, is never going to stand for capital punishment, or is absolutely going to be for capital punishment. Well, Bork goes up, and he decides to get in an intellectual debate with the Democrats, who then control the Judiciary Committee, and it turns out not well. They go after him really, and I was a Kennedy fan, but Kennedy really went over the line, went after him viciously. They started taking out his movies. They started really attacking him personally. And it got so bad that finally Reagan just yanked him because he said, I can't. They told him, you're not going to, the Democrats are not going to approve him. Well, the Democrats end up with Scalia, who, if you're a liberal, Scalia is far worse. He's smart, he's tough, he writes well, he's energetic, and he's very, very persuasive. He is one of the great conservative voices of the Supreme Court in its history. And he's been here 25 years now. So they didn't have Bork, they got Scalia. Then after Scalia, of course, comes Thomas. And you all remember Thomas and the hearings involving this sexual harassment, which changed a lot in this country. He's been there 20 years. He's not a tremendous influence, but he's a conservative vote. Rehnquist, as he starts to get ill, then, of course, he dies. I think he actually died in office. Sometimes they, you know, one time Harlan Stone in 1946 actually died on the bench, right on the bench. And there's an interesting story about Jackson, but I guess I won't go into that because I heard that at the Scorpions. So who gets appointed? Well, at that time, Bush is president, and they're looking around, and now they've gotten smart. I mentioned the thing about the Pope before. You know, we Catholics, we elect popes. We don't elect them at 50. If you're a day under 80, you're not getting in. I mean, you know, they're all old, and then they live forever. You know, it's unbelievable. Except the one pope, I guess, who lived for 2 months in 1970. Yeah, right. Well, there was a question of how he went out, but so now they've gotten smart. So now they're appointing people who are younger. Democrats do the same thing. They appointed Kagan. I think she's probably in her 50s. And if you're there for life and you're in pretty good health, you got a 30-year run in front of you. The Byer, he's not much. I mean, he's been on there. Clinton appointed him, I think, in '96. He's been there, what, 16 years? So Roberts gets appointed to be the chief. And Roberts, I think, when he gets appointed, is either in his late 40s or early 50s. How old is he?
46.
Yeah, okay. So 46 when he was appointed?
47.
Okay, so there you are. So he could be there forever. Then Alito gets appointed, and he's even further to the right, and he's also young. So now Roberts is there, and it doesn't make a difference. As many of you know, the change of administration, he will remain the chief forever. Stevens mentions Roberts. He didn't spend a lot of time. I think Roberts only been the chief 3 or 4 years when he was there. There's no question that Roberts, I mean, you take some of these men and women, the Democrats, well, there are 3 women on the Supreme Court now, all liberals. The 5 Republican-leaning people, conservatives, are all men. The chief, when you look back, you look at Rehnquist, you look at Roberts. His intelligence is tremendous. Phi Beta Kappa. I think he went to North Carolina and Harvard Law School, or went to Harvard and graduate and summa cum laude. They're just extremely, extremely bright. One thing he doesn't talk about in the book, because he's really pulled his punches, and that is the influence of Clerks. Now, a lot of these judges, and good or bad, but nonetheless, they have tremendous egos. They said Douglas had been on the court so long, he could just dictate the opinion off the top of his head, and he'd give the cites the opinions. He'd actually give the cite, not Smith versus Jones. He'd give you the book because he'd written them. And one time the story goes that Douglas, somebody was leaving town, and said, oh, I got to stay and write. And he said, don't worry about it. He said, I'll write the opinion for us. So he writes the majority and the dissent. He doesn't put his name on the majority, but that's the way he did it. Clerks have tremendous influence on judges. It is said of Rehnquist, though, you make your own judgment on this, never hired a minority or an Oriental, and may never have hired a woman as a clerk. I mean, you really got to wonder about this. Back in the year 2000, he's never hired anybody. They're going to hire really bright clerks. And for many of the judges, and you can see their style. When you see Scalia, for example, he has a certain style in writing. Other judges are much less adept at, or much less assiduous in reading this stuff. He mentions this, Stevens, in his book, that Frankfurter, he thought terms he'd see Frankfurter in all argument. He thought Frankfurter hadn't read the brief yet. He asked a lot of questions. But he thought his impression was that Frankfurter was really learning the case as he was going along. The chief, I think, gets 4 clerks. Everybody else gets 3 clerks. It goes from October through the end of June, first week in July. So they're wrapping up now. I don't think they're hearing any oral arguments. The arguments now are not nearly what they once were. The caseload of the Supreme Court is not nearly what it once was, because they've streamlined the appellate process, whereas before they had to take certain cases, they don't have to take it anymore. They are not overworked. They leave in July, they come back in October. And when they'll appoint, I think the clerks are there for 2 years. So they have a constant rotation. So 1 year, 3 leave, next year 3 stay, that kind of thing. But someone, for example, like Scalia, or on the left, I suppose you were to take Ginsburg, you could write a draft opinion, but she's going to make sure that comes out exactly the way she wants it. He points out things that we knew anyway. Oral argument does not usually change the minds of many of the judges. What's interesting, sometimes you may have seen this, and they don't publicize this, which is too bad, because I think a lot of people would enjoy seeing it. You will start seeing 2 judges fighting with each other through the lawyer. Well, counselor, the court said this, didn't they? And, yes, Your Honor. Well, counselor, on the other side, I'm sure you meant to say this, didn't you? And you realize that they're having a big battle right from the Supreme Court. The stories are legendary of people who've just stood up before the Supreme Court, just freeze. My name is, oh my God. I mean, it's a pretty scary thing. Some people, for example, have been Solicitor General. They've been in front of the Supreme Court 20, 30 times. It's really a phenomenal institution. And as I indicated before about the power of appointment, if you want to know the power of appointment, how that can be, really, we know it's important. The chief judge will appoint certain people to do certain tasks, administrative tasks. And that can control a lot. In 1996, there was a special prosecutor in Washington, I think his name was Finch, who had completed his work and then either through health or whatever, left. The D.C. Circuit Court of Appeals appointed a follow-up. His name was Ken Starr. And Ken Starr, had it been a different appointee, I don't think there's any question that it couldn't have been any worse for Clinton. So that's the power of the appointment. So the chief judge, in terms of that, can really make a difference, a subtle difference. Okay, now I've been going a half an hour. Joe, should we take questions now? Yes.
In this forthcoming election, 2 of the oldest judges on the court happen to be liberal, Ginsburg and Breyer. Now, if Romney were to win,
yes,
and he were to appoint 1 or 2 judges, the assumption is they would be conservative. And as you said, the conservative judges are now maybe 5-4. Then it seems the court would be conservative almost forever. Whereas if Obama had to replace Ginsburg, he would replace it with another probably liberal. I mean, the two people he put on.
Right,
So,
right.
so basically, by having a Romney, that would throw the court more to the right. And as you said, the younger judges are mostly conservative. Then it would maybe 30, 40 years before the court could change.
You don't know. You've got, that's a good point. Now with the information that we now acquire, more people are aware, it's not just lawyers know this, the importance of these appointments. And now it's even more critical because in the old days, the politicians would go to somebody, for example, I mentioned Eisenhower. Somebody in New Jersey was a friend of Ike's and said, why don't you appoint this guy Brennan? Later, Eisenhower was horrified at what he had done. Now, with regard to Ginsburg, you're right. If Obama gets the appointment and Breyer and Ginsburg, you would assume you can bet on it. He is not appointing Antonin Scalia to the Supreme Court. Kennedy is older. Kennedy's now probably got to be in his mid-70s. I don't have their dates of birth. But yeah, the next 4 years, that's really critical. And in fact, as I said, Bush Sr. and Reagan, their appointments really carried the day for in the year 2000. And this goes back to the presidency also. When you have a chief executive, since so few cases or so many fewer cases go to the Supreme Court than they used to, the president appoints all the judges. It gets approved by the Senate, which has been a big fight, to the courts of appeals. And so what happens is a lot of your either liberal conservative judges will be appointed by the president to these courts of appeals who also serve for life. When you're in the federal government, you're there forever, so you may be dead and they don't know it. But, and I can tell you from my own practice how important this is. In the Court of Claims, if you bring a lawsuit against New York State, you have to go to the Court of Claims. Court of Claims judges are all appointed by the governor, approved by the Senate. And it's pretty simple. You walk up, Steve Coffey, okay, fine, he's appointed. When you sue the Court of Claims, you had, Pataki was the governor for 12 years. The great majority of the appointments now in the Court of Claims are Pataki appointees who are conservative, who are pro-government. If Cuomo or Spitzer and Patterson Cuomo now have 8 years, you will have the very same case, factual cases, which will all likely, in many ways, be decided differently because of the nature of who the appointments are. So you're right. You got Roberts and you got Alito. They're young, but no one knows. But they're there for, I mean, they're going to be there a long time. Anything else? Yes?
When did Justice Stevens retire?
He retired, I think, in 2010. He started in 1976, so he was 34 years. And he was in, for a person 90, he was in pretty good health. I mean, he could still, quote, do the job. The problem you have, in all honesty, is that if you're 90, there's no possible way you can be dedicated to the way that, say, a younger judge can be. But the stories are legendary. Douglas, you can take them all. They will hang on. In fact, in an election, everybody knows that you'll have a judge, Judge X, I think Senator Day O'Connor was say, be dying, and they will stay that last year so that the president who has the appointment gets the appointment the following January. Now, traditionally, and it can happen this year, if a judge is going to retire, there may be whisperings inside, but they're pretty careful about that. They don't announce the retirement until the last day of the term. And so what will happen theoretically is the last day of the term, you could have Anthony Kennedy announce that he is now going to retire from the Supreme Court. Now, there's not going to be an appointment this year. It'll never get through the Senate. Although, if Kennedy's worried, or Scalia, say, for example, he'll wait till next January, and if Obama wins, big deal, and if Romney wins, then he gets his appointment. Yes?
If that is so, then where is separation of power? Like, it seems to me that then Supreme Court or judiciary is not an independent body. It is just totally dominated by the executive branch.
Well, that's a good point, and that's the feeling. It's really philosophical as much as it is political. So, for example, you'll see someone like, I'm using Scalia, who will write opinions that will confound. I mean, he's conservative. There's no question he's conservative. At least he does something. At least he asks a question once in a while. Thomas just sits there. But he will write opinions sometimes that are different because he has his own view of life. Everyone's predicting, for example, that the health care bill is going to be declared unconstitutional and it's going to be 5-4. And it may be, but it may not be. You may get someone switching who says, I think that the Congress had the power to do this under the Commerce Clause, or you may have an opinion written in a way, because this opinion means a lot in terms of the future of the government, how they can control things. That's why these concurring opinions become important, because someone may say, I'm going to go with you on this, but I'm not buying anything else. Roberts and Alito, although both conservatives, and I'm not a constitutional scholar, so I don't want to pretend that I am, have displayed already some differences of view. But as far as political parts, absolutely. Look at Citizens United. Citizens United is the case where, and Stevens writes about that and says later they'll prove that I will be proven right. That is a case where the Supreme Court under the First Amendment has said you can give as much money to a candidate as you want because you just give it to the PACs. So you have this fellow in Las Vegas giving Gingrich $10 million. You have the Koch brothers giving 15, 20, 30, $40 million. The Democrats, same thing. But it is political. There's no question it's political. And yet, do you have a separation? Yes, but that's why they're appointing them. It's more political than ever. That's because you're not going to get that independent person anymore. It's just not going to happen. Yes?
Is there, does religion among the justices play any role? Their religion?
No, I don't. No one now says it does. Maybe 50, 75 years ago, Brandeis was on, who was Jewish. But I don't know how many Catholics are on there. I don't think race, there are no blacks on the Supreme Court. There are 3 women. Oh, yes, Thomas, I'm sorry. There's 1 black, there's 3 women. I'd have to go back and look, and I guess there's at least 1 Jew, a couple of Catholics. I don't even remember, but no. Are there 5 Catholics? But it doesn't.
You have Kagan, Ginsburg, and Breyer.
But that part where they have to balance it off, what they did in the past. I remember when Johnson talked about putting Marshall on. He said, "I want my own black on the Supreme Court." Only he said a little more colorfully. But those days, I think, are pretty much done. I mean, you're going to try and balance it. Let's face it, you can't, there's no possible way we're ever going to go to the Supreme Court again without having women on the Supreme Court. But religion, I don't think religion's a factor anymore.
Yes, Steve. I was recently reading about the Aaron Burr case. Thomas Jefferson was trying to prosecute him, and the judge on that case, before he became chief judge, was John Marshall. Mm-hmm. The question I have is, the legal term, we hear it all the time in courts, probable cause. Is that as simple a term as it sounds, or is it wide range encompassing, or is it a vague term? What does it actually mean?
That's a very good point, and in fact, that's how we make money as lawyers, because we make sure you don't know what it means. I guess it pretty much means what you want it to mean. And probable cause, in terms of a criminal context, in terms of a civil context, can mean, do you have a right, probable cause to take a certain act? So, for example, it can mean very little. You can be arrested, all you need is probable cause. So I walk into a police station and I say, someone hit me or someone attacked me, you've got probable cause. Now, if you get a search warrant, then you have something a little different. The standard's a little different. You mentioned Marshall. Many of you know Marshall. I mean, he was there 30 years at the Supreme Court. And it's funny, not funny, but we think about the great, the presidents, and we all think about that. And we think some of the great legislators, Clay and Webster and so forth. If we had not had John Marshall in the first 30 years really establishing the independence of the Supreme Court, even with the political part of it, this country could have been far different. I mean, he stood up to Jefferson and everybody else, and he really laid the framework for this great court. And that was Marshall. Now, you've had bad decisions, you know, Taney in 1856, the Dred Scott decision, but, and there's a lot of bad decisions, but one thing about the Supreme Court, you've never had, at least publicly, scandals. We don't know their decisions. So, for example, do certain people get whispered about? Yes. And I'll give a very good example of the integrity of the Supreme Court. In the Brethren, Tom Clark, who had been an old Supreme Court justice, came back to the Supreme Court and had lunch with one of the judges. And a friend of this judge, I forget, it might have been Douglas or somebody, and there's a case pending. And Clark started asking him how it was going, or maybe he should think about it. And I think Clark may have had some financial interest in it as a lobbyist. And the judge was horrified. And he said, Tom, are you asking me now to do something for you? Now, 100 years ago, it was a lot different because the judges and the presidents, of course, had a lot of contact. But there really is a lot of integrity. Cases don't get leaked. We haven't had any leaks yet coming out of the Supreme Court. Now, does the president know right now what the result's going to be in those two cases, the immigration case and the health care bill? Maybe. He may know. He may have gotten the word. We don't know. But that part has been very well, carefully kept over the years. Yes?
Has there ever been an effort to put an age limit on Supreme Court justices?
Yes. In an indirect sort of way, it was the packing. Roosevelt, who was not happy with what was going on in the Supreme Court in the 1930s, then devised this plan in which he said for every judge over 70 on the Supreme Court, because he said they're too old, they can't do the work and everything else, the president up to the number of 15 would be entitled to appoint someone else. So that really was the age, because it's constitutional to serve for life. Well, as many of you know, of course, even his own Democratic Congress went after him in the Senate. But it did work in reverse in a way, because then they were smart. I mean, again, as far as politics, they don't get on the Supreme Court because they're stupid or they can't read the tea leaves. So I forget who the chief judge, it might have been Hughes at the time. Roosevelt is really attacking them in their inability to work, and they're declaring all these New Deal piece of legislation unconstitutional. Right around the time that this case, or that the proposed bill by Roosevelt is pending before the Senate, what do you know? The Supreme Court comes down with a decision or two upholding the constitutionality of certain statutes. So, and he writes a letter saying we worked very hard and all that kind of stuff. But he was smart. So I'm sure because there's all kinds of stories. They got together and said, listen, we can't keep doing that. We're going to get killed here. But there's no real age limit now. No, they're there forever. And the Court of Appeals judges, as I said, are appointed for life. There are judges, there's one I think now in Montana, I think, or someplace out west where the judge is 94. When you're a district court judge, you're appointed for life, and what can happen is you go on senior status. And so then you put your name up if you want to travel, and you can travel to any place in the country that has an opening that needs you. So, for example, if I'm a senior judge, if I want to, there's one judge in Albany who works like crazy. That's McAvoy. He just works. But some other judge may take senior status, which means you're basically semi-retired, or you can be, and you put your name in, and gee, what do you know? You got to spend a month in Hawaii, and they're not killing themselves in Hawaii. So that's the age problem. Yes.
Well, how do you feel about the Supreme Court decision on the presidential election 2000? I've been reading lately a lot of criticism of the Supreme Court, that it might have been a political decision. How do you feel about that?
I don't think there's any question. Even no one's going to deny that, really. No one will seriously deny that. We all have a point of view. Now, if I were on the Supreme Court at the time, it would have been 5-4 the other way. What happened in that case was there was going to be a recount, which the Florida Supreme Court had held there will be a recount, and the majority said there would not be a recount, and therefore I think Bush won by what, 900 votes, whatever it was. It was minimal. The real question was, why was the Supreme Court now entering into clearly, they said, well, because it's a federal election, we have jurisdiction. But the other side said, at least I thought validly, that's a state court. It's a state election. Even though it's for president, the recount applies solely to a state court, which you have absolutely declined to interfere with in the past. I think that Florida had a right to know what the votes were, and if Bush won, then he won. But there's no question that was political. They can say what they want. All you had to do was look at the divide there. So, but you're right about this. They are clearly political decisions, and sometimes overtly so. So, I mean, you look at the Second Amendment decision that came down a year or so, the right to bear arms. The Supreme Court has never held that before. You had a conservative. Now, they may be right, but nonetheless, that's the way they felt. The Guantanamo Bay detainees, where the conservatives were fighting that, and said we should not introduce ourselves into that. The real critical part about this, though, is so few cases now get to the Supreme Court. Your Second Circuit cases, for example, Joe Bruno, everybody knows about the Bruno case. That case was decided by the Second Circuit. That'll never go to the Supreme Court on retrying them again. Those courts have enormous power and not appreciated oftentimes as to what happens in terms of schools, in terms of religion, in terms of handicap, disabilities, taxes, all this stuff. Yes?
Isn't the Congress holding back on approving a lot of federal judgeships?
Yes, and what's happened is,
And what is the effect?
well, it's disgraceful on both sides because they always point, well, you did it, now we're doing it. Not as much in this sense because the Democrats control the Senate. When the Republicans controlled the Senate with Clinton, they were holding everybody back, which now you've got these enormous amounts of vacancies throughout the country because they just wouldn't bring them up for a vote. The Republicans now, on those judges that they consider illiberal, will tell the Democrats, if you put them up, we're going to filibuster, or her up. So we'll fight you on that. If the Republicans were to take the Senate in 2000, let's say the Democrats. Romney, let's assume he gets elected in 2012. The Democrats retain control of the Senate. Come January, now they can't do that in Supreme Court because there's too many people watching and it's too important. But on all the other federal appeals judges, now Romney sends names down to the Senate because it has to be approved by the Senate, not Congress. And the head of the Judiciary Committee says, well, we're going to take a very careful look at Judge Smith. And 3 years later, they're still looking at Judge Smith. And so what happens is you have gaps and you have vacancies. And that's the fight. And it's disgraceful. It really is, because both sides do it. So, yes.
Andrew, the Supreme Court went against one of Andrew Jackson's actions, and he said, where's their army?
Right.
And
yeah, he said,
okay, now flash forward to the Vietnam War. I thought the court was extremely cowardly in not making a decision on that, why we shouldn't have. Do you think it was because they knew they had no army that they felt they couldn't make that decision?
You know, there's probably some good books written on that. You're right. Where's his army and his, as Jackson said about Marshall, fine. Now that he's declared, now let him enforce it. I think it was the Indian situation. Yeah, in the Seminoles. So Douglas, every year, that's actually a very good question. Every year, it came up to the Supreme Court why we're in Vietnam, and the president had an undeclared war, which could only be done, if you know, by act of Congress. You just, Obama can't wake up one morning and the tail wag the dog decide to take in Albania. So Marshall and Douglas every time that would come up, apparently we're fighting. To get certiorari, to get to the Supreme Court, unless you have it as of right, and that's more complicated, you need 4 judges to take that, to take it in the Supreme Court. And Douglas, who was by old and feisty at that time, didn't care, kept fighting. We got to take this issue about whether or not this war is unconstitutional. And therefore, but the majority said, we can't do this. If we do this and we get it up here and we declare the war unconstitutional, well then every troop in Vietnam comes home, or Congress has to vote on that war. And you're right, they never addressed that issue. It was one of the really hidden issues as to why the Supreme Court was not facing that issue of Vietnam. Because we were at war. We clearly were at war. So, yes.
Has there ever been a time where the commitment of a majority to their dogma has seriously threatened the credibility of the institution of the court?
Well,
and I ask that because of my concern of our present court.
Well, there's some cases back in the early part of this century. You had a lot of reactionary, a lot of anti-Semitic, racist judges back then. We did. I mean, the country was that way, and a lot of these decisions reflected that feeling. So, for example, on the right to labor laws and a lot of the other laws, and the segregation laws, desegregation, which the Supreme Court wasn't touching. I mean, some of those cases were just awful, and you wonder how could they possibly do it. A political philosophy, Dred Scott. In 1856, in the middle of this, Taney is the chief judge. He's from Pennsylvania, but he's a Southern sympathizer. They declared that Negroes were not human beings. That's a pure political philosophy. I mean, the North went, of course, and they should have. That's one of the great sparks of the Civil War. But yes, the philosophy. Now, if you're a conservative, in all honesty, the conservatives will tell you that the Warren Court, Earl Warren, became so activist and so liberal that it changed the whole society. They allowed pornography, and they allowed abortions, and they did this, and they did that, to really reflect their political philosophy. And the Supreme Court does have a political philosophy, and it's crazy not to think they do. They absolutely do. The question is where the balance comes in. And so when you have, for example, in the First Amendment, I could tell you, people who disagree, Citizens United, when you allow corporations to put billions of dollars and to turn the election over, I think that's a political decision. They're saying the First Amendment, they knew exactly what they were doing. But that's what they're doing. That's why when a president appoints someone to the Supreme Court, he ain't going to take a chance on David Souter anymore. If he's living in the woods, he wants to know what's going on in the woods. Believe me, they are so sanitized by the time they get in there, they know exactly where these judges are going to be. Now, that could change, but in the last 30 years, it hasn't.
About the Chief Justice, why don't they have a seniority that whosoever has been there longest can become Chief Justice? Because
that's not the way we do things. I don't think it's constitutional. I think it's statutory. And I think it would be, my own personal view would be a mistake, because you need fresh blood on the Supreme Court. But they're never going to that a seniority basis. Another reason why you wouldn't do it, if you did it that way, theoretically, I mean, the senior member is going to be the oldest member, and you could have somebody 85, 86. Stevens, 87, when Rehnquist died in, I think, 2006, I forget now when it was. He was 86 or 87. You don't want an 87-year-old being the chief judge. Anything else? Okay, thanks very much.